An independent medical exam is an evaluation that is set up by the employer or insurer. Typically, the work comp insurer will set it up. It's allowed under the workers' compensation statute, and essentially, even though it's called an independent medical exam, we call it an adverse exam. And the reason I say that is that it's an exam that is set up for the purpose of litigation. It's conducted to defend the employee's claim. So the insurance company is choosing a physician that they think will evaluate the employee in a way that's favorable to them. I will often tell clients, when you go to an IME, you have a doctor who does this. They take off their treater glasses and they put on their independent medical exam goggles. And they're still a doctor, but they're viewing you differently than they would if they were a treater. So when you go for an independent medical exam, first off, it's not something you need to be afraid of. You do need to go. If you don't go, there's a penalty for that. Your case basically gets suspended or could be dismissed. You need to go. You can get reimbursed for your mileage. You can get reimbursed for your lost time in attending that exam. When you go, you want to be truthful. You don't want to volunteer information, but you want to answer the questions accurately and understand that you could be under surveillance during the time that examination is being conducted. It may not be that you're being followed into the office by an investigator, but it could be the doctor's watching you out the window and seeing how you ambulate and move about. And I've seen that description in many independent medical examination reports after the fact, where my client didn't realize they were being watched out of a window. Now, I don't want somebody to be overly paranoid about an independent medical exam, but these are some of the things you need to be aware of. You don't need to take medical records to that exam. Sometimes you'll get a letter from the insurer that says, I want you to gather all of your medical records and take those to the exam. That's not the injured worker's job. That's the claim adjuster's job to make sure that the independent medical examiner has the records that are needed to conduct that evaluation. And at that exam, the doctor will perform a physical exam of you and will review your records, will take a history from you. The doctor isn't going to tell you what the doctor thinks. All right, there is no patient-physician relationship that's established because this is, as I said, an adverse exam, or what the statute calls an independent medical exam. You will receive a copy. The injured worker will get a copy of that report, typically 4 to 6 weeks after the exam is conducted, and usually the insurance company will mail that out to the employee after the exam has happened, or will mail it out to their attorney, whichever is appropriate. And in terms of the weight of that exam, it's not God's truth. Okay, you may have picked that up in how I was answering the question earlier. An independent medical exam is simply a piece of evidence. It's a medical expert opinion, and it may coincide with your doctor's opinions. It may not. It may be an outlier. And once in a blue moon, it will support your case as an injured worker, but usually it doesn't. That's why the insurance company chose that physician to conduct your independent medical exam.